Welcome. This is WOW second edition 2021. Our panel today is about to speak on issues of ethics and international arbitration. My name is Jose Antonio Rivas. I'm co-founder of Washington Arbitration Week, together with Ian Laird from Crowell & Mooring. I am a partner at Strategy LLP, which is a boutique law firm here in Washington, D.C. in international arbitration, both investor state and commercial arbitration, and matters of public international law. I have the task of introducing Ben Love, who is a partner at Boyes, Schiller, and Flexner. Ben is today's moderator, and he has done quite a bit of coordination and work towards putting this panel together. So kudos and thanks to Ben. I would like to say that Ben is recognized as a global leader in international arbitration and public international law. He has represented clients in more than 50 commercial and investment disputes under all major arbitral rules, including some of the most high-profile matters submitted to international arbitration over the past decade. Ben has assisted clients in obtaining favorable settlements, securing awards in excess of $1 billion on multiple occasions, and defeating several attempts to annul high-value exit awards. He has particular experience in disputes relating to the exploitation, production, distribution, sale, and purchase of hydrocarbons and natural resources, as well as related infrastructure. This includes numerous matters in Latin America, Europe, Asia, and Africa involving mining sector, upstream hydrocarbon sectors, and agreements to supply natural resources, including natural gas, pipeline, and LNG, and other commodities. He also teaches investment law and arbitration at Brooklyn Law School, and he also has a presence in Washington, D.C., as well as in New York. And I could keep on going, but I do not want to embarrass Ben by reading his whole set of accomplishments. So Ben, with you, our moderator, take the floor, and thank you so much for being in Washington Arbitration Week.
Thank you, Jose, and thank you to others who helped facilitate and organized this panel. It's my pleasure to serve as moderator today. Of course, we're going to be talking about ethics and international arbitration, and not just arbitrator ethics, but also counsel ethics and other participants in the arbitral process, with the central question, which we'll get to throughout this panel, of whether we are now at a time where a code of ethics for one or all of these actors is necessary. And it's my pleasure to introduce our distinguished panel of speakers. First, we have Rose Remo, who is the founding partner of Remo International Law, a boutique law firm in Washington, D.C. Rose was a Fulbright scholar at the University of Ghana School of Law, where she taught investment and international commercial arbitration, general principles of arbitration, and contemporary issues in arbitration, amongst other subjects. Rose focuses her practice on investor-state arbitration, international business law, commercial litigation, and international commercial arbitration. She was also an adjunct professor at the Université Paris II, Panthéon-Assas, and Université Paris XII, where she taught fundamentals of the English and American legal systems, as well as international business law. Rose was recently appointed ABA advisor to the Uniform Law Commission Study Committee on the Singapore Convention on Mediation, and she has been appointed president, co-arbitrator, and sole arbitrator in investor state and commercial disputes involving African states. Rose is also a barrister and solicitor of the Supreme Court of Ghana and was appointed to the Permanent Court of Arbitration by Haiti. And Next, our next speaker will be Todd Weiler, who is an independent international arbitrator based out of Canada. Todd has well over 20 years of experience working in investor-state disputes, mainly as counsel. He is a prolific speaker and author. He holds LLMs from the universities of Ottawa and Michigan in international trade and international investment law, respectively, as well as an SJD from Michigan, which yielded a 2013 book entitled Interpretation of International Investment Law, a book that is celebrated for its historically informed approach to treaty interpretation. Todd now spends most of his time serving as arbitrator and consulting as an expert on international investment law and in international disputes. Our third speaker will be Ignacio Totorola, and Ignacio is a founding partner of GST's Washington, D.C. office. He has a distinguished career of 25 years as a dispute resolution attorney, in which he has served as lead counsel, sole arbitrator, chairman, and tribunal member in more than 70 high-stakes international arbitrations. He has been named a leading arbitration practitioner in Latin America and worldwide by Chambers Latin America, Chambers Global, and Legal 500 annually since 2015. Ignacio has extensive experience in complex international law matters under most, if not all, of the major arbitral rules and in a variety of industries. He formerly defended Argentina, Bolivia, and Ecuador against investment disputes and has trained government officials from these and other countries under the auspices of UNCTAD, and is a frequent lecturer at the Columbia University Centers for Sustainable Investment, where he trains foreign government officials on preventing and defending themselves against investment disputes. Ignacio also served as a diplomat and as counsel for the government of Argentina with respect to its ICSID disputes. And on behalf of Argentina, he negotiated the 2010 arbitration rules, the 2012 ICC rules for disputes involving states and state entities, and represented Argentina before the WTO, the UNCTAD Investment Committee, and the OECD Investment Committee. And last but not least, we have Daniel Müller, who is a founding partner of FAR Avocat in Paris. Daniel is a member of the Paris Bar and has extensive experience representing and advocating for states as counsel on numerous occasions before international courts and tribunals, including a number of cases before the ICJ, the International Tribunal for the Law of the Sea, and various arbitral tribunals. Daniel has also represented investors and states in investor-state disputes before ICSID tribunals and before tribunals operating on the UNCITRAL rules. And among Daniel's many publications is a recent one on ethics in investment treaty disputes. So with that, I will yield the floor to Rose, who will start us off with an overview of the topic at hand. Rose?
Thank you so much, Ben. I take the opportunity to also thank Jose, who's always thought of me and put me on this platform. So thank you so much. If I can share my screen, I'm just going to go straight into it because I know we have a lot to say. Let's see. Okay, great. I was about to get very, very worried. I said, oh my God, I can't find the slides. My job will be quite easy because I am going to leave the heavy duty to Ignacio, to Todd, and Daniel, who will come, but I'll just give just a quick overview of what we are looking at when we talk about ethics in international arbitration. I will skip the first few slides because I think just giving you a background and then go inside the presentation would probably best. International arbitration, we know, is a wide global practice, and we have different legal traditions, but two main legal traditions that would say, at least I see in my practice, is a lot of the common law versus the civil law. And by having those different type of legal tradition, I would say that it caused some form of lack of uniformity in the applicable ethical rules when we talk about ethics in international arbitration. So with that, we see that in the past few years, there's been many different proposals as to how to handle or how to properly present ethics in the international arbitration community. First, we can look generally for the ethic rules for arbitrators and counsel. We could say that the IBA guidelines on the conflict of interest is usually what many of us, we look to when we are speaking of the conflict of interest, impartiality, and all those green line, yellow, orange, and all the other stuff that we know that the IBA guidelines would provide us. These are very core principle, but it's still a guideline. It's just a soft law. On the other hand, when we look at the lawyers' regulation, it has not been consistent at all, but mainly because we know that the lawyers are attached to their own particular jurisdictions, and this is where you will have the difference between the common law and the civil law, what should be ethical, what's not. And the tribunal doesn't have any coercive power anyway to force these lawyers to abide by any set of rules. So then what? We've seen that many have had different proposals. So one of the proposals that many suggested is to have a universal code of ethics for counsel in international arbitration. With this code, they are proposing to have a global arbitration ethics kind of body to review any conducts of lawyers and arbitrators or all the participants in international arbitration. With that also, we see in 2014, LCIA revised its arbitration rule by providing guidelines to the parties, legal representative that are mandatory in all LCIA arbitrations. And the AAA has done the same thing as well by providing some standards. But we have another code. This code has not gotten a lot of attention. Maybe Ignacio can correct me if I'm wrong, because it's the Spanish Arbitration Club code. He probably is very well aware of it, but it has not gotten much attention. So the Spanish Arbitration Club has two codes. One was in 2005, one in 2019. The 2005 was really focusing more on arbitral institution. The 2019, on the other hand, after they've reviewed the 2005, they realized that the international arbitration community, they were seeking to have all participants in arbitration to have some kind of standards when it comes to independence, impartiality, transparency, and professionalism. So therefore, by 2019, the Spanish Arbitration Club said, hey, we might as well come up with the new code, and that's the 2019 code. And I personally have gone through the code. I think it's phenomenal. Now, the CBP, the Code of Best Practice, it's a set of soft rules, a compilation of lots of recommendations that the Spanish Arbitration Club would provide to the international community. And the rules deals with arbitral institutions, arbitrators, lawyers, experts, and as well as third-party funders. And I thought that was extremely interesting to see that they've thought. And I must say that when you look at the code, and you see a lot of people in the international community, high profile individuals who are engaged in the drafting of the code. But yet it's still not binding unless the parties adopt it in the arbitration agreement, or you put it in the TOR as the arbitrator, so you're not going to have to be able to enforce the code. Quickly, I'll tell you here, it has about 6 sections and 4 annexes. So it's a code that I would encourage everyone to take a look at, because I think it covers, it's actually a precursor, I would say, if I may, of the idea to have a universal code of conduct for all the participants in the international arbitration. I'll go to some of the sections that I thought was very essential. For instance, the arbitral institution section, this is like section 1. It's on the one hand, it says that arbitral institution, they are there to organize, administer arbitration process while applying the principle of independence, impartiality, transparency. And on the other hand, they have this duty to ensure due process and fairness of awards. So therefore, the Spanish Arbitration Club felt the need, the arbitral institutions needed to be regulated as well. I won't have time to go into the rules for those regulations, but you can take a look at them if you have some time. I just will set the stage for my co-presenters. The second one is the section 3, was showing to you the duties of the arbitrators, not different from what we know, but there is one duty they call duty of abstention, which we'll go through a little bit so you can have an idea what the Spanish Arbitration Club did in this code. Basically, arbitrators are the key to ensuring good outcome in an arbitration. The mission is to resolve disputes by applying the procedural and substantive rules that applied in each case. So essentially, the trust that they will fulfill their mission with impartiality, independence, without favoritism towards any of the parties is essential for arbitration to be showing as a good system of justice. So that's the main reason they felt like they needed to.
Rose, could I?
Yes or no?
I don't mean to interrupt you, but there are 2 points I'd like to make as moderator at the moment. One is I wanted to see whether you could put your slides into presentation mode so that they fill the screen, because I've got a couple of questions about the visibility. But then I thought I might also ask anyone who's not speaking to put their microphone on mute, because we're getting a bit of background noise from someone on the line.
Okay, how do I do that, Ben?
It should be, I mean, if you...
most likely if you press...
You can go to view,
5.
or you can go to slideshow, I think.
Okay. Advanced sharing option? I don't know.
A little, no, not in Zoom, but in PowerPoint itself. If you
press,
right in the very bottom right-hand corner, that little square should do it.
You can press F5.
Okay, that helps.
Try that.
Okay, no, that's I have a Mac. F5. No.
You have a Mac. You go to slideshow. I mean, if you click slideshow. You have it.
It's at the top of your toolbar.
Okay.
In the middle.
New slide. I see new slide.
No. Further over to the right.
It is between animations and review.
Up top.
No, too far. There you go.
There you go. Slideshow.
Oh my God.
No, you missed it. Slideshow. Here. One more over. There, stop. Slideshow right there.
Click that one, Rose.
You should, if you be able to click that little box in the far right-hand corner, that should also do it.
And my assistant is not here.
Rose,
Oh
also,
my
if
goodness,
you go
this
down,
what an embarrassment.
Rose, if you go down at the right side, you see like a little image that looks like a glass of wine. If you, no, More in the right. No, no, no. That one.
Okay.
That one, yeah.
Ooh,
You got it.
is that it?
Perfect.
Yes.
Oh, thank you, Maria. Thank you. Is that
You're welcome.
Maria?
Yeah, yeah, yeah. That's me. You're welcome.
Thank you. Okay, my apologies. So I'll go straight to the some of the example with Article 74 of the code. It says that all arbitrator candidate must, without undue delay, refuse the appointment if A, they harbor any doubt about their willingness or capability to perform their role without bias towards any of the parties. B, there are circumstances which, in the view of a reasonable and informed person, give rise to justifiable doubts about their impartiality. That's very, very important, because you see, like with A, if the arbitrator think like, well, you know, there's no conflict, I can take this case, but yet if you still have things there that reasonable, informed person could justifiably think that it's impartial, you still should not take the matter under the code. And the one that I thought was really important as well was the necessity available time to adequately perform their role. I could go more into details when they have questions, because this is important. We see there are some arbitrators who just keep on taking. One I checked last time had like 30 cases. I think it's very unconscionable to have so many cases open, and when others could basically take those cases. So if you're not available, you should not take the case. We have here like the duty. See, now I cannot read my screen because it's okay. So we ask, okay, is that where I was? I think so. Yeah. So now you look at the duty of for the lawyers. You said the lawyers have to be acting with integrity, and of course the clients have the right to hire and fire the lawyer, and also the prohibition of ex parte communication. And Article 15, for instance, a lawyer shall refrain from knowingly making false affirmations, both in the written submission and also before in oral pleadings before the tribunal. Also, you're not allowed to do any citation that distort the meaning of the law. And sometimes there are lawyers who are overly zealously, and they are doing different interpretation into, they distort the meaning of the law. With that, under the code, Article 132, when you breach, there are a few things that could happen to you. First, if it's a small breach, I think you would go and caution the lawyer verbally and in writing. B, you can draw inference when evaluating the evidence, and C, lawyers' conduct into consideration when you are drafting the award. But the D is what's really interesting, where the tribunal would actually have a duty to contact the Bar Association where this lawyer is admitted to submit some form of complaint. But the only problem is, some jurisdictions you need to be a lawyer to appear before the tribunal. Other jurisdictions you don't need to be a lawyer. So therefore, what if you have an engineer? Who do you contact? So I don't know the answer to that. I guess that will be up for discussions where my co-panelists can further discuss. And then finally, they can adopt other measures that they find necessary. And a quick few words I wanted to say, the third thing we see happening was in 2020, ICSID and UNCITRAL, they released the draft code of conduct for adjudicators. Then here again, it's only adjudicators. Meanwhile, the Spanish code covered everyone. And I didn't have time to go into everyone. You can take a look at it. Even third-party funders, they cover. So the code was developed. This code here, ICSID UNCITRAL code, is for ISDS reform. And all member states are involved, and the draft actually addresses independence and impartiality of arbitrators and adjudicators. And it is based on the comparative views and standards for that, of course, that they find in investment treaties, arbitration rules, etc. I won't say much about this because my colleague Ignacio will go very deep into it because he's been before UNCITRAL and can really add to the conversation. So the question is, are we ready for a universal code? I said not yet, because I don't believe that we are ready. When you look at the 2019 Code of Best Practice by the Spanish Arbitration Club, it covers all the proceedings, all the parties in the proceedings, while the ICSID code and UNCITRAL code covers only the adjudicators, and also all the codes, they're just soft law, and unless they are adopted somehow, the parties are not going to follow them. And what we would like to see perhaps in the goal to have this universal code of conduct is perhaps for the ICSID and UNCITRAL to start looking at the codes that would actually impose some duties on the party representative. And that's it for me.
Thank you very much, Rose. That was a wonderful overview of the activity in this area in recent years. Now let's turn it over to Todd, who I think has some specific case study examples of ethics in action and some thoughts on those. Todd?
Thanks, Ben. I'm going to just talk about a couple of things. We all have only so much time, so I'll try to go quickly. So we can just switch to the first slide, Maria. I only have 2 slides, by the way, so this shouldn't take too long. I was looking at Article 4 of the UNCITRAL Draft Code of Conduct for Arbitrators in International Investment Disputes the other day, and I posted something on OGMed, and everybody thought it was interesting, so they thought maybe I should just chat about that again, maybe reprise it. So when you see this, oh, we've gone one too far. There you go. So Article 4 of the draft code. So I wasn't at the UNCITRAL proceedings, unfortunately. I really wanted to, but it just didn't work out. You can see in Article 4, there's 3 options that have been given for the double hatting problem. One is this full prohibition idea. The other is a modified prohibition. And then this other one is disclosure. When I look at this, I think of like when I was a bureaucrat, and when you wanted your decision maker to do what you wanted, you gave them 2 more extreme examples for 1 and 3, and then that would kind of force them to choose 2. So I'm not sure if that's what they were aiming for here, the people who drafted this, but the thought crosses my mind. I think the problem, though, is that any prohibition, whether it be this full version or the modified version, is really unnecessary. Especially if you consider what the targeted mischief is supposed to be here. I think it's already addressed, let's say, perhaps in Article 3, E, there's an admonition here that says you shouldn't use your powers to advance any personal or private interest. Well, it seems to me that pretty much covers it. There's also some problems, though, with a top-down approach to rulemaking, which is a bigger problem, not just with this particular provision, but with codes generally. It's that it operates on a default sort of assumption that more is always better. And I think it largely ignores the potential impacts in terms of the complex interplay of incentives and that exist, many of which are already in play without a code. Indeed, it reminds me of Hayek's famous observation that the curious task of economics is to demonstrate to men how little they really know about what they imagine they can design. Examples of poor design here. The idea in the prohibition that you would have the same treaty as a condition. Well, that's completely superfluous if you think of the fact that the same legals condition would certainly cover it. But what about the same legal issue provision, or in square brackets, the substantially same legal issues provision? Well, in my opinion, I think it's not only just unwieldy, it's also practically unnecessary. It's unwieldy in the sense that it covers everything. As Mark Cantor, replying to my OGMed discussion, pointed out, he gave a litany of examples. He said that in all of these, you'd find in almost every treaty arbitration, treaty interpretation under the Vienna Convention, the relationship between national law and international law, the role of good faith under international law, bifurcation, trifurcation of proceedings, and procedural issues surrounding it, elements of a legal standard for challenging the arbitrator, elements of a legal standard for granting provisional measures, elements of a legal standing for applications to dismiss, burdens of proof, test for investment, due process substantive challenges. It goes on and on. The question then becomes, what legal issue, whether you call it substantial or not, wouldn't be covered under this catch-all? It seems like everything would be covered. And again, if I go back to the mischief that this double hatting provision appears to be concerned about, it's covered by the idea of advancing one's personal private interest. So let's think about this in a scenario sense. Let's think about scenario one. So acting as an arbitrator in case A, Mr. X cajoles his colleagues into rendering findings of law upon which he hopes to rely as counsel in case B. Now, does anyone seriously think that the case B tribunal members are going to be amenable to basing that tribunal's legal findings on a case A award after they learn that Mr. X sat on the case A tribunal? I think Mr. X would probably be apt to avoid any mention of the case A award so as to avoid placing the case B arbitrators in a very uncomfortable position. Placing them in such a provision, it seems to me, could actually only serve as an impediment to achieving the desired result for Mr. X's client. Scenario two, acting as counsel in case B, Mr. X exhausts his arsenal of arguments, seeking to convince the case B tribunal of a position that he, sitting as an arbitrator in case A, is working hard to convince his fellow tribunal members to adopt. He doesn't disclose to anybody the fact that he's serving both roles concurrently, and somehow IA reporter, GAR, the administrators, nobody seems to cotton to the fact. So Mr. X bides his time, expecting that the case A is going to wrap up in time for him to submit the case A award to case B tribunal as counsel and win the day. Unfortunately, or let's say maybe fortunately for Mr. X, case B goes sub judice well before case A tribunal renders its award, and that's the end of the story. So given how there really is no scenario in which a double hatter can reasonably expect to benefit from seeking to rely on findings made as an arbitrator in another case in which she served as counsel, it seems to me that there really is no reason to require disclosure of an issue conflict of this nature, when the only thing that our two cases have in common is, let's say, they're both about expropriation. What case isn't about expropriation? So I wonder if there aren't unexpected results here. Somebody suggested to me offline in that OBGYN discussion that perhaps what we're doing here is we're sort of pushing an arbitrators guild, which will become even more cloistered from the rest of the arbitral community. And if that happens, because people have to choose either strictly only counsel or strictly only arbitrator, you end up amplifying the phenomenon of arbitrator to arbitrator conflicts. A recent example, and by the way, Maria, you can switch to the second slide. A recent example of this occurs in a U.S. District Court for Southern District of Florida decision involving the famous Panama Canal arbitrations. And in that scenario, you have challenges that go nowhere because I almost thought that the judge was going to say that he had a big fat nothing burger here, but he restrained himself and actually just used judicial language. But the examples you see there were all mentioned. They were all mooted in that case. But the judge just didn't see anything that rose to the level that was applicable under the U.S. federal standard. What I found most interesting, though, about it is the experts who were used. So first you have Jack Coe, and then you have Chiara Giorgetti, then you have Gary Bourne, then you have Jack again, then you have Cherry again, then you have Gary again, and then Stephen Schwabel. All of those opinions can be found in that one single case where they all discussed and debated what code applies and whether arbitrators should or shouldn't be appointing each other to tribunals as a tribunal member, not as counsel necessarily, or serving coterminously as counsel and arbitrator in unrelated cases. very interesting. And the best part is, as you can see by that little pink thing there at the bottom, that's my short URL I created for the case. And you can read all those opinions yourself. I think it's Juice Monday, if I recall correctly. So that's it for me. I hope I kept it under 10 minutes, and I hope I stimulated everybody.
Thank you, Todd. I think we'll have much to talk about that once the primary presentations are done. But let's go ahead and move on to Ignacio, who is going to speak about some related topics of arbitrator conflicts. Ignacio.
Thank you very much, Ben, and good morning to everyone. I'm happy to be here with you today. Honored to be part of this Washington Arbitration Week, which I think it's a very important occasion for all those practicing international arbitration, investment arbitration in Washington, DC. Indeed, I celebrate the idea that Jose Antonio and Ian had about creating a Washington Arbitration Week. It was very much needed. I think that somehow I'm going to disappoint some people in the audience, because I'm not going to be talking very specifically about the new reform process or the code of conduct. I mean, we can do it in the question and answer section. But my presentation is more on the policy sides of things and what can be done in order to improve our international arbitration practice, but specifically our investment arbitration practice. And well, we all know that challenges to arbitrators, it's very costly to the parties. Thank you, Maria. I'm going to get there and I'm going to let you know. But you can leave this on the screen. It's fine. Thank you. I was saying that it's very costly for the parties in international arbitration to challenge an arbitrator. I mean, I think that we need to depart from that point, and that any seasoned practitioner notes that by challenging one arbitrator, a party risks upsetting the entirety of the arbitral tribunal, or at least is going to upset that arbitrator for the remaining of the proceedings. And I also need to say that a challenge is expensive. It's expensive because it's expensive in time. It will stop the proceedings, and it's expensive in actual money. Off the top of my head, I can say that maybe it's going to cost something close to $100,000 to each party. It's going to cost some $1,000 to the arbitrator. I mean, in arbitrators' fees for the arbitrators to make the decision. It might go to the center. It creates also a reputational cost. So the question is, what is that it can be done in order to prevent these kind of situations? And I wanted to bring to your attention the experience of Peru, the country, but not as a party in an arbitration, but the situation that currently takes place in that country as a consequence of the thousands of arbitrations that they entertain every year. And maybe, I'm not sure whether those in the audience are aware, but Peru is a country in which the disputes between the states, the domestic disputes between the states and the state contractors, according to procurement laws, have to be decided through arbitration and not by recourse to the local courts or administrative tribunals. So Peru has thousands of arbitrations every year. And maybe I would suggest that it's even busier than the international arbitration world. And because of that, I think that they have created some practices that I would consider to be good practice in international arbitration. And in Peru, arbitral institutions are required, and in turn, arbitrators are required to produce a full disclosure. And however, the full disclosure is not left to the individual decision of the arbitrators, but is prompted through very specific questions that are being asked from the arbitrators. And this is the policy suggestions that I would like to make. Because, and maybe if we go one slide up, Maria Lucia. Anyways, one more, please, or two more. That's the one, the exit, the exit disclosure form. Thank you very much. When we look at the exit disclosure form, we are going to see that is a promise by the arbitrators to keep themselves, to keep the information obtained in the arbitration confidential or judged fairly as between the parties. And then they can or cannot attach a statement in which they are going to disclose the information that they deem necessary to be disclosed. So the decision making on what information is going to be shared with the parties is the information that the individual arbitrator decides to share. In Peru, because of the number of cases, the regulations have gone one step further. And I would like to say that this is not something that is novel, even in international arbitration. During the presentation, Ben mentioned that I was part of the ICC committee for disputes involving states and state entities, and one of the suggestions then was to have a disclosure form similar to the one that I'm going to suggest. And maybe this is something that has already been adopted in some institutional arbitrations in the United States, but I'm not aware of any. But if we go down a couple of slides, I would like to share with you the kind of questions that are one up, please, there. No, one down, please. Another one, please. Next, this is the one. Thank you very much. The one that begins with one, yes. For example, in Peru, the arbitrators are going to need to state the number of arbitrations, institutional or ad hoc, in which they have been appointed arbitrator by the parties in the arbitration or by companies associated to the parties or entities related to the parties in the last 5 years. Also, they are going to be required to provide detailed information regarding the dates on which they were appointed, the party that appointed, and the start and end date of the arbitrations. They are going to be required to state the number of arbitrations in which they are participating with other arbitrators in the case. And if we go to the next slide, please. They will need to inform the parties if they are currently sitting or they have sat in a case with the in which they were appointed by one of the attorneys in the case, and then in general they will have to inform the parties of any professional relationship with the parties, the representative lawyers, advisors. I sit as arbitrator in Peru in several cases, and I can tell you that this is a guideline that helps, first of all, the arbitrator himself to assess what it can be important for the party to know. And secondly, it provides the opportunity for the parties to understand and avoid the need to come through the internet in order to assess whether there is a conflict of interest or not in a situation. What I think is that in the current state of the practice, there is somehow of a practical shift in the burden of proof. It is for the parties to discover possible conflicts when we should try to avoid the conflicts to begin with. So, I mean, to conclude, I'm bringing this to your consideration because I think that the arbitration community should avoid the real conflicts of the perceived conflicts of interest before those conflicts take place. And I know that this idea of putting very specific questions to the party has been entertained in international arbitration, and I'm wondering whether we are at the time in which that kind of information is going to be disclosed. And I speak now from my perspective and my personal experience. If you just sign a form, you can hide information. On the other hand, if you need to respond questions, a person will be almost in a position or in a situation of lying to those reading the statement. So it increases the burden on the arbitrator to reveal the information that it can be important for the parties for the parties to understand whether a conflict of interest exists or not. And as I said, it's a policy suggestion. At the end of the day, it's going to be for the states that are currently negotiating this new code of conduct, either at ANSI trial or before ICSID, to adopt a policy like this. But more importantly, the message that I would like to convey to you all is, first of all, that no one likes to bring a challenge, that challenges are very costly for the parties bringing the challenge, not only in money, but also reputation, time. And so I believe that the arbitral community should work together in order to anticipate these kind of problems. Because at the end of the day, when those challenges are revealed, it is the entire arbitration community, the one that suffer the consequences. And thank you.
Thank you, Ignacio. Now we'll turn the floor over to Daniel, who I think will focus a bit more on regulation of counsel ethics and international arbitration. Daniel?
Well, thank you very much, Ben. Not sure we will do this for reasons I will explain, I think, and which have already been touched upon by Rose in her first presentation. I will probably more focus on whether it's actually necessary or even feasible to put into place this kind of universal code of ethics for counsel in arbitration, in international arbitration specifically. So, but first of all, I mean, I think Rose actually touched already quite nicely on this point. A clear difficulty about ethics for counsel in international arbitration is certainly that we all come from different legal traditions, we have different legal education, we have our own ethical rules, in the bars where we are admitted to, and I'm only speaking about people who are admitted in only one bar, because already if you're admitted, I don't know, in Paris and New York, this does already create problems, and I'm not sure how people solve those. So I'm speaking only in my capacity as a pure French admitted lawyer in Paris, and will point probably a little bit to difficulties which I can see in this kind of idea of a universal code. The first problem is that we see things differently. What is entirely acceptable for Anglo-Saxon lawyers, for instance, seems to be obviously barbarian for continental trained lawyers, French lawyers, German lawyers, or people like this. This has been quite nicely explained in several publications where actually they go to different specific ideas. Just to name two of them: preparation of witnesses on the one hand, and document production procedures on the other hand. You just don't lift this thing in the same way. So there's already a first problem. It's not specific to international arbitration, by the way. It actually comes up all the time where international lawyers or lawyers from different backgrounds will have to come together and to work together or against each other in international tribunals. International Court of Justice, same problem. We did have the same problem within Europe, where lawyers actually can circulate quite freely and provide services also in other countries. And well, in Europe, it was actually solved by adopting a European code of ethics by the professional or a kind of, the Council of Law Societies of European countries, which has adopted a European code of ethics, and which today is included, for instance, as an integral part into the French code of ethics, and which tries to solve some of the problems on the European level. However, on the international level, so international arbitration, well, first of all, it's actually quite interesting to see that none of the arbitral rules, which we know and which we usually practice, with the exception to the LCIA rules, which have included some general principles, speak about ethical obligations of counsel, specifically on counsel. It's quite often it doesn't go any further than to say, well, the parties can be represented by counsel. But this also means that a party does not necessarily mean to be represented by counsel. And then the question already arises, why counsel working for a party should have specific obligation to the tribunal or to the other party, and the other party representing itself should not have the same kind of obligations. So quite often, the arbitral rules are actually silent about those issues. And that's certainly not fully accidental because, and this has been quite nicely shown by the tribunal in the Rum Patrol versus Romania case, well, the role of counsel and the role of arbitrators, which are regulated, which we have seen, are quite different. So we as counsel owe our main obligations, not so much to the tribunal, but to the clients. At least that is my understanding. We have to present the client's case in the best way possible, still respecting the obligations or the rules which are fixed for the arbitral process. So the national rules of ethics are different, of course, but of course there has been, on the other hand, a development of quite a number of soft law rules. Rose has actually provided a quite useful list. I just wanted to add, there is already a 1919 United Nations Declaration on the Role of Lawyers in Society, which already fixes a little bit our, rules which should be respected by all lawyers in the exercise of their profession. But then we have the other well-known rules. It certainly starts with the 2010 Hague Principles, which are not specifically targeted at international arbitration, but at all kind of international tribunal, international court activities, so state to state or investor state. But you have a number of others. I do certainly include the IBA rules on representation of parties in international arbitration and the IBA rules on conflicts of rules, which touch upon issues of ethics. And at the end of the day, the Spanish code for arbitration, which Rose has already mentioned too, is certainly a last example or a more recent example of these kind of principles. So developing soft law is certainly not bad. The only issue I do have with this is that it actually levels down the different ethical obligations we all have. And pretty much all of the codes start with a kind of a general reservation saying, well, this does not override any of the other ethical rules which a lawyer will have to respect in its own jurisdiction. And there are difficulties with this, because, for instance, in France, preparation of witnesses is just a practice which is not admissible under our ethical obligations. And it went so far that the Paris bar adopted a specific resolution in order to adapt this principle for arbitration procedures. Actually, they said, well, of course, French lawyers would be unfairly treated if they could not prepare their witnesses compared to the practice which is entirely accepted in other jurisdictions. So for arbitration, it's okay, right? It does not only level down the principles, it also settles a certain agreement between all of us that the procedure and the principles which we should follow are mainly Anglo-Saxon oriented, right? So that's, and we as continental lawyers, we just accept it because we just use the same processes all the time, specifically in ICSID. Document production is a very good example. But here, I just wanted to point also to the Prague rules for the efficient conduct of arbitration procedures, where the arbitral tribunal is supposed to have a much more active role, also in collecting evidence and stuff like that, which will certainly also influence the ethical rules of lawyers which have to be committed there. Another problem of those soft law instruments is, for me, that they actually only tortured the efficiency of the arbitral procedure or the integrity of the arbitral procedure, mainly the relations between counsel and the arbitral tribunal. It does not so much speak about the obligations we as lawyers have to our clients, right? Obligations like professionalism, competence, integrity. And that's maybe very difficult to be implemented even in an arbitral process. There's a good example, a very recent example, in the case De Sutter versus Madagascar, which is just an annulment, and the annulment hearing is online. ICSID has put it online, and it's on YouTube. And Madagascar, in this procedure, the annulment procedure, for instance, claims that the arbitral tribunal should have exercised its inherent powers in order to assure that Madagascar is correctly represented by the council which represented Madagascar. So in principle, Madagascar is now claiming, well, the council we had was bad. We didn't do a good job. But, how far does it go? It's certainly, on the one hand, a responsibility of the party to engage counsel, but it's also a responsibility of the counsel not to accept a case where he actually thinks, well, this actually goes over my capacities and my knowledge. So that's a very tricky issue, and I'm not sure that any of those soft law instruments has actually tackled these problems. And there's a real reason for this too, and that comes back, Rose has also spoken about this, who will implement those rules? Well, of course, the arbitral tribunal can and must assure the integrity of its own process. But that's not actually everything, right? It can certainly go to some extent to draw inferences or whatever by counsel conduct. But, on the other hand, if the counsel is actually, doing applications or requests which will only prolong the procedure, at the end of the day, the tribunal will decide, well, this will be handled in the cost order at the end of the day, and the party will probably be responsible for more of the costs than the other party. Well, but why should the party, take up the risk of its counsel's work? So that's also an issue. And Rose has also spoken about the remedies which are foreseen in the Spanish code. This shows already also the difficulty. The tribunal can't impose any kind of sanctions or so on council, that's normally within the responsibility only of the professional organizations, law societies, etc. But on the other hand, if council actually overstep their duty to the tribunal, I'm not very cautious with the tribunal or whatever, I mean, that's normally a problem that, at least in internal law, is not solved directly between council and the tribunal, but only by kind of mediation with the law society. In France, the bâtonnier actually plays a very important role in those conflicts. And we don't have this in an arbitral tribunal. So how would an arbitral tribunal be able to deal with these issues except by, you know, sanctioning the party for its council conduct? So there are actually quite a lot of difficulties, even if tribunals are not very shy in imposing certain remedies in order to safeguard their own arbitral process. Everything which goes beyond that is clearly out the reach of an arbitral tribunal, and without any kind of international bar, which we don't have. And I think it's a good thing that we don't have these kind of things. But it's impossible to impose such a code and to make it work. Thank you.
All right, thank you, Daniel, and thanks to everyone for a very interesting overview of some of these issues. I want to, one of my takeaways from the various presentations here is that everyone seems to acknowledge, or all the panelists at least seem to acknowledge, that there are some issues that are not ripe or even fit for codification. And I'm just wondering, and I'll start with Todd on this, but I'd also like Ignacio's views because he touched on this issue a bit less. Are there any issues that are fit for codification in this realm of ethics, whether with respect to arbitrators or with respect to counsel, or should we really just leave it to practice in real time, commentary, etc.? What do you think, Todd?
I'm inclined towards the latter because the question isn't even so much a should, but rather a could, as Danielle just suggested, or I should say explained. It seems infeasible to actually be attempting to do so. I understand why organizations like on TED would want to do this, but I'm just not sure that it's a great idea. Why would they want to do it? Well, because there's been complaints, obviously, about investor-state arbitrators. I don't think many of them, if any of them, are well-founded. But this is basically, it has the appearance of doing something. It's an old political saw that basically the best government is the one that appears to be doing something. Whether they actually are doing something doesn't really matter. They just have to appear to be doing something. And drawing up codes is a great way to appear to be doing something for an institution. But that doesn't mean that it's practical or that there aren't unforeseen consequences, as I suggested with my reference to Hayek. So I suppose I would have to say no. There really isn't anything. We all have our bar ethics, and if anything, it seems to me that perhaps we could focus on getting people to be more steadfast and true to their existing ethics requirements, rather than trying to pile on new ones that maybe people will adhere no more strictly to as well. And we should always contemplate, of course, that in the end of the day, whether that be for counsel or whether that be for arbitrators, there are other more tangible means of sanction, such as overturning an award or a costs penalty. So we have mechanisms. Maybe we should just learn to use them better.
What do you think, Ignacio? Sorry, you're on mute, Ignacio.
Yes, I'm sorry for that. Thank you, Ben, for the question. And I think that first of all, I think that I have the opposite view. I really think that that a code of conduct is necessary, and I'm not sure that it cannot be enforced. I mean, first of all, I agree with Daniel that it's better not to create an international bar, and lawyers should be, lawyers' conduct should be sent to the local bars for the local bar, or the bars where they are bar or register should decide the conduct. But that doesn't mean that the tribunal doesn't have any power to enforce it. I mean, as Daniel suggested, first of all, the tribunal can make an award on costs to the party. And we all accept, I think, in international arbitration that tribunals have inherent powers, and the tribunal's inherent powers should permit the members of the tribunal to make some kind of to pass a sanction to that lawyer, and finally the file or the conduct can be sent to the specific bar. I'm not sure whether the tribunals in the future are going to take a more active role, because we are a small community and we all try to avoid issues in which we that could affect our colleagues. This is a small community, but at the same time, I think that there are some conducts that should not be tolerated. I have one specific case in which I was counsel for one state, and counsel on the other side created a document in order to obtain jurisdiction. And it's not something that I'm saying that happened, but an expert was hired, and this expert tracked down the document and find out that the document had been created the night before by the lawyers involved in the case. And should we sanction these kind of practices that affects everyone, not only those that acted illegally, but also the other members of the international arbitration practice? My response to that is yes. I think that the code of conduct is going to be mandatory for those practicing, say, before exit. And at the end of the day, it's a guideline. But without the guideline, we cannot, unfortunately, leave the decision-making about whether our conduct is ethical or not to ourselves. Unfortunately, some practitioners are are willing to enforce that rules very strongly, and some other practitioners do not. So I think that at least the arbitral tribunals and the institution should have some power in case of ethical breaches. And I also wanted to make a very short point, if I'm permitted, about why ICSID or UNCITRAL are dealing with this code of conduct. And this comes from from a need being expressed by different states. And I can tell you that being in the UNCITRAL meeting last week or 2 weeks ago, the need for a code of conduct was overwhelmingly supported by those attending, either in person or through the internet. So I think also that we as the arbitration community should hear what other stakeholders are also saying, and try not to close to ourselves, because this is not just about those practicing investment arbitration, but it is also about the legitimacy of the system.
All right, so we have a question from Jose Antonio. Would an international code of conduct adopted an investor-state arbitration deflate one of the reasons to push for a permanent investment court in replacement of arbitration tribunals. Rose, I'll let you take that one.
I don't think I'm looking at. I don't think it would replace it. I think it would work in complement. For instance, I wanted to add to what Ignacio said. I too was before UNCITRAL, and I follow the debate. And I think the fact that you have all the member states involved. This is the first time like, for instance, we see so many African states giving their opinion with the process and taking charge, I would say, by submitting different proposals. Really show us in the international community that the states are ready to see changes. And I think that if you look at how, if we want this universal code of conduct to work, eventually you'll have to go through the national laws. And the reason I say this, you see the model law, the UNCITRAL model law, we still have a new state signing every day or getting to be part of the UNCITRAL group. So I think the fact that UNCITRAL is taking the lead with this ISDS reform, getting all its members involved, and then now ICSID is trying to come in conjunction with UNCITRAL. I think we can get somewhere. And I actually believe, like Ignacio, we need to have a code of conduct because my experience, for instance, coming from both civil law and common law and having practiced in Paris and in Africa, and I could say there is some commonality. We all know that the arbitrators, they need to be independent. We all know that the lawyers have to be ethical. So I think we could get to some middle ground. It's UNCITRAL. They have many different treatises that having us signed to it. Look at now, we have a mediation, the Singapore Convention. So I think it could take years to get all the states to agree to a standard, but I think eventually we can get there. So to answer Jose's question, I don't think it's going to affect it. I think it will complement it.
Yeah.
If I may, I think that if the double hatting provision takes the form of a prohibition, you're actually driving arbitrators into a guild, and therefore the only answer to the problem described in the Panama cases would therefore be to have an international tribunal. So in a sense, going down that road actually gets you to a standing tribunal.
Yeah. So Daniel,
just a little bit to what Todd said in order to bring some peace of mind. I mean, I don't think that the total prohibition is going to be adopted. I think the position states took in the deliberations were very reasonable. And I think that some form of codification, it's going to be adopted, but it's not going to be the total prohibition at all. I mean, that is my view. And very quickly, I'm sorry for taking more time, maybe Ben, I know that you want to give the floor to Daniel, but something that Rose said about the need to make these codes into local law. I mean, I really believe that that is not necessary. The Mauritius conventions indeed shows that it's not necessary, because when these international agreements are adopted by states, that through the internalization of the international law in their own legal systems is going to become law. So I think it's going to be more effective than just going through the congressional approval case by case.
Yeah.
So how do you expect the local bar to actually abide by it? For instance, I don't know. I'm looking into the future, because like Daniel mentioned earlier, with the, in France, where I'm also licensed to practice law, we have different code of conduct, and you see he mentioned about some kind of arbitration or mediation between the bâtonnier, but we also have some unwritten rules. For instance, you will not see a French lawyer come in to try to rat another French lawyer. It's just you just don't do that. So when you look at arbitrators, we are likely to recommend our own friends and who we know and who may be another lawyer. If there is something that's being done, how do you get to sanction this arbitrator, for instance, in France? So I think we need to, the national law, it's not an impediment because it may take years, but it will be properly done where now the bar associations won't, they can just apply it. That's my opinion. I don't know.
Thank you, Rose. I'm going to ask one last question to Daniel, and then I think we need to open up to our audience to ask questions. So Daniel, you had expressed a pretty clear opinion that it would neither be, I think, possible nor appropriate to have an international code of conduct for counsel or an international ethical code for counsel. Does that same view apply to the code of conduct for adjudicators that's been proposed by ICSID and UNCITRAL?
I don't think so, because they're in a quite different position, right? I mean, these are the people who are supposed to do justice, and their obligations vis-a-vis the process are quite different. I think it's much easier to fix, conflict rules or specific requirements on education, professionalism, etc., for arbitrators, which are already in the rules, right? The code of conduct, which then goes onwards to say, well, you shouldn't speak to the parties. I mean, that's a little bit self-evident to me. I don't know. I don't know why we need to write it down somewhere. We all know that it's inappropriate, right? And actually, every time it happens, we all complain about the fact that it did happen. So why do we need to have it written down? I do have more problem with, a code of conduct for lawyers. I mean, counsel to be discussed by states or by ICSID or whatever. I mean, this is clearly for me against one of the basic principles, which is independence. Why should states be able to put this actually on the table like this? It should be actually us lawyers preparing and fixing our own code of conduct for ourselves.
All right, thank you, Daniel. I know there's lots more to say about this, but I've been instructed to take us to the breakout rooms. So, thank you to all the speakers for your contributions.
Thank you.
Thank you very much.
So I think we'll see everyone in the breakout rooms shortly.
Thank you, Ben. Thank you so much. We are going to. I'm quickly going to explain the logic of the breakout rooms. But before doing that, I would really like to thank you, Ben, for moderating this panel, because as we saw, there's no single opinion on this. There's no consensus, and that's why it's such an interesting panel. I mean, there are backgrounds as many of you are arbitrators, but also many of you have been counsel, backgrounds in terms of who you have represented, and that it somehow shapes some vision of investor-state arbitration, public international law. And as we saw in this panel, it was fascinating to see how there's no one single consensus on whether there should be an ethics code applied to counsel or solely to adjudicators. But in any event, thank you, Ignacio, Danielle, Rose, Todd, and of course, Ben, for doing such a fabulous job in presenting the issues and featuring all the different perspectives. And with that, now we're going into our breakout rooms. What I would ask you to do as panelists is make sure that when you receive the invitation to go into breakout rooms, you do accept it and say yes, because otherwise you're going to stay in the main room. And once we do that, you'll be able to sort of network or socialize or talk further about your issues concerning an ethics code with our esteemed audience. Thank you very much, and have fun in the breakout rooms.
Thank you very much, Jose.
Thank you, Jose.
Thank you.
Thank you.